The United States Supreme Court on Wednesday, September 1st, refused to block a Texas anti-abortion law that bans termination of pregnancy after 6 weeks. The 5-4 majority decision of the Supreme Court has raised questions on the right to abortion and the conservative approach of the court. What is the law that was challenged? In May 2021, the Texas legislature enacted SB 8, the Act. The Act, which took effect at midnight on September 1st, makes it unlawful for physicians to perform abortions if they either detect cardiac activity in an embryo or fail to perform a test to detect such activity, even though this could be months before a viable fetus develops. Legal experts have noted that the wording is designed to make it very difficult to challenge the law in courts. Laws that outlaw an activity are enforced by the state. However, according to the New York Times, the Texas law gives rights to private citizens to sue anyone who performs an abortion or aids and abets a procedure. Plaintiffs who have no connection to the patient or the clinic may sue and recover legal fees as well as $10,000 if they win. So the question before the Supreme Court was whether the Texas law can be challenged in courts with the state of Texas as a defendant. On both moral and religious grounds, a strong anti-abortion movement is in place in the United States. In India, the Medical Termination of Pregnancy Act allows abortion up to 24 weeks of pregnancy. What has the court ruled? In a 5-4 majority opinion, it has refused to block or grant a preliminary injunction against the law despite a constitutional right to abortion that the US Supreme Court had recognized in the 1973 verdict Roe v. Wade. What does a refusal to block mean? The emergency ruling refusing to block is akin to a refusal to grant an interim stay of legislation by Indian courts. While Wednesday's ruling does not stop the Texas legislation from facing legal challenges, it also ensures that for the first time since Roe v. Wade, such a stringent anti-abortion law is enforced. Other Republican states too have introduced similar laws, but they have not yet been implemented as they are challenged in courts. According to the NYT, these include Georgia, Mississippi, Kentucky, and Ohio. How has the US Supreme Court ruled earlier on abortion? In its 1973 verdict in Roe v. Wade, the Supreme Court had ruled with a 7-2 majority that undue regulation on abortion violated the 14th Amendment to the Constitution, which guarantees due process in laws. Despite several attempts to overturn the ruling, Roe v. Wade stayed as the precedent that protected women's rights to bodily autonomy. Also, the 1992 verdict, Planned Parenthood v. Casey, recognized that laws outlawing abortion are unconstitutional if they place an undue burden on a woman seeking an abortion before the fetus is viable. What question does the latest ruling raise? The obvious fallout is the enforcement of a regressive anti-abortion regime that would violate the rights of women. Another question raised is about the US Supreme Court's practice of handing out preliminary or summary rulings that could vastly affect civil liberties, a practice that is referred to as shadow docketing.